Important Supreme Court decisions. This lecture is about several Supreme Court decisions that affected American history, that were controversial, or that helped create the system of civil rights and personal liberties that we have today. This case, Plessy versus Ferguson from 1896, is often considered one of the worst Supreme Court decisions of all time. This case is where the Supreme Court upheld separate but equal segregation laws in the states. A law that was passed in Louisiana in 1890 had ordered railroads to provide separate railway carriages for the white and colored races. It stipulated that all passenger railways had to provide these separate cars, which should be equal in their facilities. Homer Adolph Plessy, the plaintiff in the case, bought a ticket on a train from New Orleans bound for Covington, Louisiana, and took a vacant seat in a whites-only car. After refusing to leave the car at the conductor's insistence, he was arrested and jailed. The court held that even though the Louisiana law required rail passengers to be segregated based on race, there was no violation of the 14th Amendment's Equal Protection Clause so long as the accommodations at issue were separate but equal. Korematsu versus United States is also often considered one of the worst Supreme Court decisions. This upheld the internment of Japanese Americans during World War II. Executive Order 9066, signed by President Roosevelt 10 weeks after the Japanese bombed Pearl Harbor, authorized sending thousands of Japanese Americans to internment camps during World War II. 23-year-old Fred Korematsu, an American citizen, born in the U.S. to Japanese parents, refused to comply with the wartime evacuation order. He was later arrested, placed in an internment camp, and given 5 years probation. Korematsu took his case to the U.S. Supreme Court in 1944. In a 6-3 decision, the High Court upheld the constitutionality of the internment program because the detention was a military necessity. Brown versus Board of Education from 1954 is the case that declared that separating black and white students in public schools is unconstitutional. Brown versus Board of Education was filed against the Topeka, Kansas School Board by Representative Plaintiff Oliver Brown, the parent of a child, Linda Brown, who was denied access to Topeka's white schools. A unanimous court overturned Plessy versus Ferguson and held that state laws requiring or allowing racially segregated schools violate the Equal Protection Clause of the 14th Amendment. The court said separate educational facilities are inherently unequal. In Mapp versus Ohio, the Supreme Court said evidence seized unlawfully without a search warrant cannot be used in criminal prosecutions in state courts. The case originated in Cleveland, Ohio, when police officers forced their way into Dalry Mapp's house without a proper search warrant. Police believed that Mapp was harboring a suspected bomber and demanded entry. No suspect was found, but the police discovered a trunk of obscene pictures in Mapp's basement. Mapp was arrested for possessing the pictures and was convicted in an Ohio court. Mapp argued that her Fourth Amendment rights had been violated by the search. At the time of the case, unlawfully seized evidence was already banned from federal courts. This case banned it from state courts as well. In Engel versus Vitale, the court ruled that it is unconstitutional for state officials to compose an official school prayer and encourage its recitation in public schools. In 1962, the Board of Regents of New York approved a non-denominational prayer for their morning procedures. Students would be given the choice to be excused for the morning prayer if they chose to. The prayer was 22 words that went as follows. Almighty God, we acknowledge our dependence upon Thee, and we beg Thy blessings upon us, our parents, our teachers, and our country. Amen. In a 6-1 decision, the Supreme Court held that reciting government-written prayers in public schools was unconstitutional, violating the Establishment Clause of the First Amendment. In Gideon versus Wainwright, the court said criminal defendants have a right to an attorney even if they cannot afford one. Clarence Earl Gideon was charged with breaking and entering with the intent to commit a misdemeanor, which is a felony under Florida law. At trial, Gideon appeared in court without an attorney. In open court, he asked the judge to appoint counsel for him because he could not afford an attorney. The trial judge denied Gideon's request because Florida law only permitted appointment of counsel for poor defendants charged with capital offenses. The Supreme Court held that the Sixth Amendment right to assistance of counsel applies to criminal state trials, and that lawyers in criminal courts are necessities, not luxuries. So Florida had to provide an attorney for Clarence Gideon. In New York Times versus Sullivan, the court said that lawsuits based on libel or defamation must show intent or recklessness. Public officials may sue for libel only if the statements in question were published with actual malice, knowledge that it was false, or with reckless disregard of whether it was false or not. The court said the First Amendment protects the publication of all statements, even false ones, about the conduct of public officials, except when statements are made with actual malice, with knowledge that they are false or in reckless disregard of their truth or falsity. In Miranda versus Arizona, 1966, the court said that prisoners must be advised of their rights before being questioned by police. Ernesto Arturo Miranda was arrested in 1963 based on circumstantial evidence he had committed a kidnapping and rape. Miranda was brought to police headquarters for questioning. After a police lineup, officers led Miranda to think he had been positively identified. They interrogated him for 2 hours without telling him about his constitutional rights. Miranda confessed to the crime. He was convicted and sentenced to Arizona prison. The court found that the Fifth and Sixth Amendments require police to inform individuals in custody that they have a right to remain silent and to be assisted by an attorney. If the police fail to do so, a criminal court judge may rule that any statements made by the accused cannot be admitted as evidence during trial. The Miranda warnings are now required before any police custodial interrogation can begin if any of the evidence obtained during the interrogation is going to be used during a trial. Loving versus Virginia from 1967 invalidated state laws prohibiting interracial marriage. Mildred Loving, a woman of color, and her white husband, Richard Loving, were sentenced to a year in prison in 1958 for marrying each other. Their marriage violated Virginia's Racial Integrity Act of 1924, which criminalized marriage between people classified as white and people classified as colored. The Supreme Court issued a unanimous decision in the Lovings' favor, struck down Virginia's anti-miscegenation law, and ended all race-based legal restrictions on marriage in the United States. The court found that the law violated the Equal Protection Clause because it was based solely on distinctions drawn according to race and outlawed conduct, namely getting married, that was otherwise generally accepted and which citizens were free to do. Tinker versus Des Moines. This case resulted in the Supreme Court declaring that the First Amendment prohibits public school officials from barring students from wearing black armbands to symbolize anti-war political protests. The Supreme Court held that students do not shed their constitutional rights to freedom of speech at the schoolhouse gate. Consequently, the court found that the student's speech can only be prohibited if it materially and substantially interferes with the educational process. Because there was no evidence of such a disruption, the school was in violation of the First Amendment guarantee of freedom of speech. In 1973, in a 7-2 decision, the Supreme Court declared that women have a constitutional right to an abortion. In 1970, Linda Coffey and Sarah Weddington brought a lawsuit on behalf of a pregnant woman, Dallas area resident Norma McCorvey, in other words, Jane Roe, claiming a Texas law criminalizing most abortions violated Roe's constitutional rights. The Texas law banned all abortions except those necessary to save the life of the mother. Roe claimed that while her life was not endangered, she could not afford to travel out of state and had a right to terminate her pregnancy in a safe medical environment. The court concluded that the Constitution prohibits laws that severely restrict or deny a woman's access to abortion, and that such laws violate the Constitution's right to privacy. The court held that, under the 14th Amendment Due Process Clause, states may only restrict abortions toward the end of a pregnancy in order to protect the life of the woman or the fetus. Another controversial case and an important case was Regents of the University of California versus Bakke from 1978. In this case, Alan Bakke, a white applicant, was denied admission to the medical school, even though his MCAT scores, GPA, and benchmark scores were significantly higher than those of some minority applicants who had been recently admitted. The court held that universities may use race as part of an admissions process so long as fixed quotas are not used. In Texas versus Johnson, the U.S. Supreme Court ruled that flag burning is symbolic speech that is protected under the First Amendment. During the 1984 Republican National Convention, Gregory Lee Johnson and a group of political activists marched through the streets protesting. When the demonstrators reached Dallas City Hall, Johnson poured kerosene on an American flag and burned it. Johnson was arrested and convicted under a Texas state law. Johnson argued that burning the American flag was symbolic speech and protected by the First Amendment. The Texas Appeals Court agreed and overturned his conviction. Unsatisfied with the decision, Texas appealed the ruling to the United States Supreme Court, which ruled for Johnson. In Casey versus Planned Parenthood, the Supreme Court affirmed the basic ruling of Roe versus Wade that the state is prohibited from banning most abortions. In 1982, Pennsylvania passed the Abortion Control Act, which required women to give informed consent before abortions could be performed, and imposed a 24-hour waiting period upon women seeking abortions, during which time the women would be provided with information regarding abortions. In 1992, after much anticipation, the Supreme Court released a lengthy, multi-part decision ruling that Roe versus Wade was affirmed, but that the bulk of the Pennsylvania law was unconstitutional. The court ruled that states may regulate abortions so as to protect the health of the mother and the life of the fetus, and may outlaw abortions of viable fetuses. The court proclaimed that any regulation that imposes a substantial obstacle preventing a woman from obtaining a legal abortion is an undue burden that violates the woman's constitutional right to an abortion. In Lawrence versus Texas, the court struck down state laws that prohibited sodomy between consenting adults. The case began with the arrest of John Geddes Lawrence, a Houston resident, by the Houston police, who were dispatched to Lawrence's apartment complex in response to a reported weapons disturbance. When the police entered Lawrence's apartment unit, they found him engaged in a sexual act with another man. Both men were charged with violating the Texas homosexual conduct law, which provided that a person commits an offense if he engages in deviant sexual intercourse with another individual of the same sex. The Supreme Court ruled that the homosexual conduct law was unconstitutional and overturned the conviction of Lawrence and Garner. The court ruled that the law violated the 14th Amendment's Due Process Clause because that clause protects a substantive right to personal liberty in intimate decisions. District of Columbia versus Heller, 2008. In this case, the court declared that citizens have a right to possess firearms at home for self-defense. A District of Columbia law banned handguns and prohibited their registration. If a firearm was already owned lawfully, it must be kept unloaded and disassembled or controlled by a trigger lock. The only exemptions were if the handguns were at a place of business or being used for recreational activities. Dick Heller, a special police officer for the District of Columbia, was refused an application to register the handgun he wanted to keep in his home. Heller then filed a lawsuit based on the Second Amendment. The Supreme Court overturned the District of Columbia ban, ruling that the Second Amendment to the United States Constitution protects an individual right to gun ownership. Citizens United versus Federal Election Commission. This case said that corporations and unions can spend unlimited amounts in elections. The court ruled that the federal restrictions on electoral advocacy by corporations or unions were unconstitutional for violating the free speech clause of the First Amendment. The ruling said that political spending is a form of protected speech under the First Amendment. In Shelby County versus Holder, the court said that states and localities do not need federal approval to change voting laws. Section 5 of the Voting Rights Act of 1965 had required certain states and local governments to obtain federal pre-clearance before implementing any changes to their voting laws or practices. And Section 4B, which contains the coverage formula that determines which jurisdictions are subject to pre-clearance based on their histories of discrimination in voting. The court ruled by a 5-4 vote that Section 4B was unconstitutional because the coverage formula was based on data over 40 years old, making it no longer responsive to current needs and therefore an impermissible burden on the constitutional principles of federalism and equal sovereignty of the states. The court did not strike down Section 5, but without Section 4B, no jurisdiction will be subject to Section 5 pre-clearance unless Congress enacts a new coverage formula. In Obergefell versus Hodges, 2015, the court declared that same-sex marriage was legalized across all 50 states. This was a consolidation of 6 cases which had originated in states like Michigan, Ohio, Kentucky, and Tennessee, representing 16 same-sex couples and other individuals. In the Obergefell decision, the Supreme Court ruled that the right to marry is guaranteed to same-sex couples by both the Due Process Clause and the Equal Protection Clause of the 14th Amendment.